my lords.
Yes.
Just 3 short points of housekeeping before I move on to ground 1. First, I've considered over the short adjournment whether or not I wish to amend my respondent's notice. I do want to move that application, and if I could pass up, please, put a big hand up, 3 copies of the effective paragraph. I'm afraid I haven't in the short adjournment been able to either take out an application notice or to formally amend the respondent's notice document, but I've done it as a self-contained paragraph.
I see.
And obviously I'll put matters in order if your lordship would like me to do so.
Yes, thank you.
Just to pick up a couple of small points from this. The first point is that on the second line, I've said that the learned judge could, of his own motion, to reflect the fact that I accept that I didn't invite the court to deal with it on that basis, but the judge could have of his own motion. And then there's obviously 2 branches to it. One, the quality of the pleading as it was before the judge. And secondly, had it have been pleaded out in the way that it's now been explained to the court, we would have said it would have had no realistic prospect of success.
Yes, I see.
The second point, your lordships asked about what the position was on the counterclaim as to threats in the original liability proceedings. The way it works is slightly complicated in that my learned friends neither admit or deny the same, and I'm prepared to accept that there's a non-admission as to unjustified threats. What they say in paragraph 18 of their pleading is that they repeat, and apologies I haven't got a copy in front of me, they say that it's their opinion that the supply of generic pregabalin for use in the treatment of pain, whilst the pain patent remains in force in the United Kingdom, would infringe Pfizer's patent rights. This would not be the case with supply or dispensing of generic pregabalin for the non-pain indications, but we believe it is incumbent on those involved to ensure that skinny labelled generic products are not dispensed and used for pain. So I say in expressing that that was what their opinion was in response to the threats, coupled with a non-admission, they were focusing not just on neuropathic pain, it was pain, and it was Pfizer's patent rights. And of course it's directed to the issue of dispensing. That material was actually taken and repeated from one of the letters they wrote to the clinical commissioning groups, the CCGs, and they just repeated it.
Yes, well, I recognise the language, but even so, I think it would be helpful if you could provide the court by email with a PDF of the relevant pleading.
Mine outgoing and the reply, absolutely, my lord.
And it's your submission that by referring to dispensing, that necessarily refers to the pharmacists as infringing as opposed to Dr. Reddy?
Absolutely, my lord. I mean, there are occasions where a doctor from his bag or her bag can dispense, but dispensing is effectively synonymous with the Pharmacists Act. Then the third...
So just to follow that up, your submission then is that the infringement was pleaded in the liability action, or at least the threats part of the liability action, and that it was determined against Pfizer by the Burst order.
It was pleaded against them. Their response to it at the time on the pleadings was a non-admission, which obviously would have had to be sought out going forward, but a non-admission with the assertion that there was actually infringement by pharmacists. So if one takes the, it's neither clearly admitted nor clearly denied what is the essence of their case. It was Pfizer's position is that the pharmacists infringed, and the dismissal of that on a Henderson basis at least could and should dismisses the claim.
Yeah. Yes. All right. Well, as my lord has said, let us have the precise pleadings.
I'm grateful. And then the third short point. I think this is the point I had some slight memory lapse on when I was addressing your lordships earlier in response to something my Lord Justice Nugee mentioned. the simplicity of the haircut, in addition to the point that I was making as to the division between losses under the threats and losses under the NHS guidance order, there is a further issue that although my learned friend puts out the possibility of a 13.8% haircut, he's very careful not to say that is going to be the answer, and indicated to your lordships that the time to work out how to put it and how to deal with it is after we've had the inquiry. And the reality is, particularly when you look at similar allegations being put against the NHS, dates such as in this, if you start trying to discount inflammatory pain claim, what happens to the recategorisation date? Are they wound up together? All of these are issues at large. And we certainly fear that when it came to the end of the inquiry, my learned friends had kept the matter going, and of course the trial to determine the issue wouldn't happen till afterwards. When it came to any reservation of payment from us, I have no confidence whatsoever that Warner-Lambert will be content to write a cheque less 13.8%. We fear on our side of the court that by the time we get there, it will be complicated, it will be interrelated, it will be matters that need to be held over until determination of the inflammatory pain part, with the consequence that either no payment is made at that time or significant reduction is made or backed by an undertaking to repay to keep us out of our money for another few years. So my clients are concerned about that. And they also point out the proportionality issue. My client's claim is a liquidated claim. It's something in the region of £34 million. 14.8% of it, I think my learned friend said, is somewhere around the £6 million, which sounds about right. That's assuming full reduction over everything. It's less than that if you, let's say you took off half for the threats aspect of it. It comes down to £3 million. I think my learned friends from the NHS said £10 million aside was spent running infringement and validity up to the Supreme Court. So one has to look at this as well on a case management basis as to the proportionality of what my learned friends are proposing as against the impact it has on the inquiry. And that's a point that the judge picked up on in the judgment as well, and my client pushed me to emphasise it.
But that's not a point with independent force, is it? I mean, if it is
case management and abuse of
if it is a good defence that Pfizer have got, and if it's not something that they could and should have raised, or they're not shut out by the order of Mr. Justice Birth, then the fact that it's an expensive point to fight isn't a good reason not to allow it, is it?
My lord, we would say it is under the certainly since CPR, since the Wolf Report, the courts under their general case management powers have the ability to ensure not only the resources of the parties but the resources of the court are used in an appropriate and proportionate manner, having regard to the overriding objective in the interest of, for example, other court users. And if I try to bring a claim that isn't worth the candle, then that is something that the court can take into account as to how much resources of the parties and of the court should be deployed in dealing with the matter.
Right.
I'm grateful, my lord. My lord, I now move on to ground one, the contention that there's a monopoly in a pattern which it has irrespective of any infringement and any right that the patentee has to prevent the alleged monopoly being traversed by third parties. Now, unlike ground three, this ground concerns both myself and NHS Scotland. And my learned friends, Mr. Campbell and Mr. Selmy, are here for NHS Scotland. In the circumstances, to avoid duplication, I'm going to introduce the key head points as I see them quite briefly, and then let my learned friend expand upon them to the extent he or your lordships consider necessary. The essence of Warner-Lambert's point is that irrespective of any infringement, the grant of a patent bestows upon the patentee some sort of monopoly which has nothing to do with infringement of the claims or the ability of the patentee to take action against any third party who is working within that alleged monopoly. And my learned friends put it on the basis, for example, in their pleading, it would be unjust and inequitable for Dr. Reddy's to recover any loss of profit arising from the supply and sale of pregabalin products, which would have been used to treat one or more of the conditions covered by the inflammatory pain claims. And the problem with Warner-Lambert's approach as we see it is that there is no monopoly for the use of pregabalin for the treatment of inflammatory pain. Indeed, the existence of such a monopoly was expressly prohibited by the Patents Act as it existed at the relevant times. And we've got section 4 in Authorities Bundle 2 at page 668. Tab 17, my lords, page 668. And in fact, this was briefly referred to in the opening paragraphs of Lord Sumption in the Supreme Court, which your lordships looked at earlier. In order to be patentable, an application must be capable of industrial application, and 4 sub 2 provides that an invention for a method of treatment of the human body shall not be taken to be capable of industrial application. It's an out-and-out prohibition. And that indeed is the background to which Swiss form claims that Mr. Austin was discussing with the court earlier came about. But it doesn't avoid the fact that you were not, as a matter of public policy, enshrined in the legislature, entitled to patent protection for the use of pregabalin for the treatment of inflammatory pain. The Swiss form claim gives a short answer, but the effect of my learned friend's submissions is that when the patent was granted, despite the claims necessarily being in very particular and limited form, nevertheless, what was granted was a monopoly entirely coextensive with the express prohibition in section 4 of the Granting Act. Now, the judge refused permission to amend for a very clear and entirely correct reason, as was raised in more detail by my Lord Justice Arnold in discussion with Mr. Bolton. The judge's phraseology of it is paragraph 31. A patent is a creature of statute, and the consequence of the grant of a patent are contained within the statute. The alleged juridical basis of the defence wasn't made out before the judge, and it hasn't been made out before this court. And in an attempt to find a juridical basis, my learned friends seek to rely upon a number of points of general discussion over the years, where judges have talked in general terms about the patent bargain and a monopoly or the patentee's exclusive right. But none of those stray references in a broader discussion amounts to any judge making a finding that there exists any form of monopoly other than that created by the right to exclude others from the market by way of an action for infringement of a patent. And as the judge put it, the patent is the creature of statute, and there is nowhere else for some other monopoly to be found. Now, the existence of this alleged non-infringed monopoly is at the heart of my learned friend's approach. Warner-Lambert accepts, at least for the purpose of this point, that the claims of the patent are not and never were infringed by anyone. And it also accepts, again for the purpose of this point, that there's nothing that Warner-Lambert could properly have done to prohibit anyone using pregabalin for the treatment of inflammatory pain, or any of the acts of dealing in pregabalin for inflammatory pain, as the judge recorded in the judgment at paragraph 38. And we say at that point, it is an alleged monopoly which has none of the essential characteristics of a monopoly. No exclusivity, no right to exclude, all the things that normally define what a monopoly is. And the problem is made more acute by the fact that to run the point, my learned friends rely upon the grant of the patent and the fact that the claims it is particularly interested in were held valid and inventive. It expressly doesn't run the point in respect of those claims that were held to be invalid. So it accepts that it needs a valid patent claim to run the point, but then fails to find the monopoly in the Act, and says in terms in its reply skeleton at paragraph 8 that apparently this isn't a point about substantive patent law at all. As we understand it, Warner-Lambert's contention is that in the light of this theoretical monopoly, it would be unfair if Warner-Lambert had to compensate Dr. Reddy's, or the NHS for that matter, for trampling upon or assisting others to trample upon its right to use pregabalin to treat pain. Just pausing very briefly there and picking up a point that my learned friend Mr. Austin made. Nobody has a marketing authorization for the use of pregabalin for inflammatory pain. Lyrica has never had, Pfizer with its Lyrica product has never had one. We don't have one. So when you talk about trampling, even trampling, the fairness of trampling on its right, it didn't actually have authorization to promote its products for inflammatory pain. So the only thing you can start to come back to, as my learned friends do, is some form of monopoly in the patent itself. But nowhere can they put their finger on it.
But why would, sorry.
No, go ahead.
Why would the absence of a marketing authorization be relevant if, let's us assume, the claims were infringed? That would be completely irrelevant.
Your Lordship is absolutely right. The point that I was making is the reason that my learned friends have to go grappling for some wrong that's been occasioned to it, something that it might have an exclusive right to, is because it can't look at outside of patent law. He says it's got nothing to do with substantive patent law. Well, where else could it be? He might have a position if he said, I am the only person on the market who has a marketing authorization for inflammatory pain.
But marketing authorization doesn't confer a monopoly.
Well, my lord, I say none of it's got any merit, and the only point that I'm making is he has got nothing to say about the marketing authorization. And when he therefore looks at the patent and he likes the fact his inflammatory pain claims were held valid, at least in proceedings by against Actavis and Mylan, he said, well, there's something I can fasten on. Patents grant monopolies, and I've got these claims, and these claims as distinct from the ones that were invalid, which therefore focuses you into substantive patent law. And then, of course, the question comes, okay, we're in substantive patent law, where does this monopoly come from? And then his case falls apart. Instead, he says, I've got this theoretical monopoly. It would be unfair if Warner-Lambert had to compensate Dr. Reddy's or the NHS for trampling on it. And unfair, you can use synonymously with inequitable. And then they say, because I've used the word inequitable, equity must rush to Warner-Lambert's aid, even though the legislature has not provided any legal right which recognises the monopoly. And with respect, we say we simply don't understand this. Equity supports the law. It doesn't create rights which are contrary to the express intention of the legislature. And my Lord Justice Arnold made the point yesterday that we moved from patents under the royal prerogative to statute provisions. And as your lordships well know, you get what the statute says, and it's not the judicial function or the function of equity to to start adding on rights that maybe could have been entertained under the royal prerogative, but certainly can't be entertained when statute has the legislature by statute has not only provided what you do get, the legislature has included an express prohibition to the very monopoly that my learned friends say it has by some form of side wind.
Well, your case is as simple as that, isn't it?
It is. My next paragraph here says,
I was
respectfully, that's the beginning, middle and end of the point.
I was looking at what Lord Sumption says in the Supreme Court when he is discussing the patent bargain.
Yes.
And among other things, he cites Section 14 of the Patents Act, which says that the claim or claims shall define the matter for which the applicant seeks protection. Yes. Which seems pretty clear. And he quotes also the European Patent Office saying the extent of, or referring to the extent of the patent monopoly as defined by the claims. Right. So the monopoly you get is defined by the claims, and if somebody doesn't infringe the claims, they're doing something lawful.
I mean, my learned friend tries to draw an analogy with contract that the judge below rejected, to say that like a contract, a patent grants the general monopoly and the infringement is just the enforcement of it. And he aligns that with contract and says, well, you've got the basic right under the contract, and the ability to go for specific performance or damages is an ancillary right to it. And we say when you look at a patent, it's the other way round. The rights of enforcement you have, infringement, generally there are a few bits around the edge, but basically the infringement right gives you the effective monopoly. And even then it's not a perfect monopoly. It's subject to Crown use, it's subject to use for your own private interest, but there are carve-outs from it. But the monopoly you get, when patent lawyers talk about the monopoly, they mean what you can enforce and not the other way around.
All right, well, you've told us that's the beginning, the middle and the end. You've reached the beginning and the middle. Have you reached the end?
Yes, exactly, my lord. For those reasons, the judge said no realistic prospect of success. I mean, I'm going to leave most of the rest of it insofar as there's anything more to say to my learned friend, Mr. Campbell. And yeah, there's a couple of very, very small points. Firstly, my learned friend tries to say that he's only running this as a shield, not a sword, as if there's some sort of difference in it. But the difficulty he has with that is that the one authority that he most likes to grab hold of is his reading of my Lord Justice Arnold's decision in the Sandoz case, to say that that was the basis upon which my Lord was granting the relief as he did in that case, absent any actual allegations, extant allegations of infringement. And we say that if that is the source of this wider monopoly, which we don't recognise, then he's already used it himself as a sword as well as a shield. And this development of the law, which my learned friend is pressing, is effectively in a scenario whereby going forward from now, I will be looking at alleged infringers. I will be advising my clients that for reason of the wording of the claim, the wants to be defendant does not infringe, but nevertheless equity will step in because he really is taking the benefit of the disclosure of my patent as a whole. Now, obviously, above and beyond equivalence. And we're one step away from effectively throwing away the claims of the patent, recognising in equity a much broader concept of an equitable monopoly. And if it exists, why can I not seek prospective relief on it? Why can I not seek compensation on it? It's convenient for my learned friend to say, I'm only running it as a defence, I'm only running it as a shield, because that's the circumstances he finds himself in. But the legal justification for that position is sorely lacking. Lord, that's short and sweet and to the point, hopefully. That really is the beginning and end of my position on ground one, but I'm sure my learned friend Mr. Campbell will add some great nuance to it, which I suspect I will agree with in due course if I'm invited to do so.
Well, short, we commend you for that. We'll think about sweet.
I'm grateful.
Yes, Mr. Campbell, thank you very much.
Oh, I already said it. Okay.
My lords, my learned friend Dr. Nicholson has taken all my best lines, but I have one or two left. I propose to start with the grounds of appeal, in particular 1 and 2, something no one else has done, and then take my lords through the judgment. And that's because I respectfully submit that whilst my learned friend has raised a number of interesting points in his oral submissions on behalf of the appellants, his actual grounds of appeal are much narrower, and this court is entitled to focus on what the grounds actually say, rather than deciding all of these interesting points. But I will, of course, say a little bit more about these additional points raised by my learned friend in his oral submissions. 4 points in the nature of housekeeping before doing that. First of all, I say immediately, it's always been our position that my clients agree with my learned friend Mr. Bolton that the court should finally decide the issue of law rather than merely deciding whether to grant permission. That's always been our position. Secondly, so far as the applications to amend the grounds of appeal, in particular ground 3, and Dr. Nicholson's respondent's notice, we have a neutral position on both of these. They don't affect us. Thirdly, I would say, however, that although infringement doesn't affect me, I do endorse and agree with all the points made by Dr. Nicholson in the subject matter of his respondent's notice about no arguable case on infringement and so forth, but it doesn't affect me because I'm not facing that. And finally, I'd ask the court to bear in mind, when going through the judgment, that this was a very busy hearing, as I think my lords have heard. Went over a number of days, a lot of parties. The judge had to deal with a lot of points, and the judgment was reserved and did come down later. But it was a very busy court with a lot of points flying around. But can I start, as promised, with the actual grounds of appeal to see what the lords are actually invited to decide? And that's Court Bundle tab 2, and in particular it's page 14 of the bundle. Now, ground 1 is elaborated in a number of paragraphs 2 to 5. The general complaint of paragraph 2 is the judge is said to have failed properly to take into account the nature of the arguments advanced in the proposed amendments. So I've emphasised the words "the nature of." Then the next few paragraphs 3 to 5 set out a particular complaint arising out of paragraphs 36 and 37 of the judgment. There's no other paragraphs mentioned in this ground. And the allegation is that the judge is said to have wrongly confined himself to issues of factual causation, somewhat disparagingly described as abstract counterfactual history in ground 4. Whereas according to paragraph 5, the judge should instead have positively disregarded such issues of factual causation and evaluated the proposed amendments by reference to what's said to be the developing legal principles applicable to the measure of damages payable on a cross-undertaking. Now, there is no criticism here of the judge's treatment of issues of substantive patent law. So there's no criticism of the findings made in paragraph 38, which my learned friend sought to criticise orally yesterday. That's transcript page 73. Nor is there any mention of the principle in Sandals 2, nor is there any criticism that the judge should not have been balancing inequities at this stage, which is the point my learned friend made orally yesterday at transcript pages 82 to 83. And if you're having a final decision, then, well, this court's going to do that exercise. In fact, there's no complaint at all here about the judge's treatment of the relative inequities. nor any complaint the judge failed to appreciate the difference between a shield and a sword, which is a distinction developed by the learned friend at several points, which Dr. Nicholson has made some submission. The only criticism is the one I've already identified in paragraphs 4 and 5 about the judge relying on issues of abstract counterfactual history, which he should have disregarded. Now, in our respectful submission, the judge made no such mistake, and it's not an accurate characterisation of the judgment. Now, to make that good, I'd invite my lords to look at this passage of the judgment. The judgment is core tab 9, and it's convenient to pick it up at paragraphs 26 to 27. There's a subheading at the bottom of page 120, but these paragraphs are at the top of page 121 of the judgment. Now, these are pleadings as against NHS Scotland, not as those against Dr. Reddy. So all the judge is considering here is the pleading against my clients, not Dr. Reddy's. We could go to the pleading itself at course 16, page 266, but it's adequately set out here. And, you know, skeleton, we've underlined the words covered by, which appear twice in paragraphs 26 and 27. Now, we can see what he means, but in a sense, it's a loose description of what the claim actually says. But as Dr. Nicholson has explained, the claims don't cover any sort of condition. As the Lord Justice Mayo and Lord Justice Arnold observed, and as Lord Sumption made clear in the Supreme Court case, the invention is identified as a manufacturing process for a novel purpose. So it's wrong to say that anything is covered by inflammatory pain claims apart from that. Now, I'm not going to take my lords to the claim itself. My lords have seen that twice. But moving on, we've also underlined the words, "this is so, regardless of whether such use in the counterfactual will have infringed the inflammatory pain claims or not." So the key point, so far as this pleading against my clients is concerned, is this sentence, namely that the argument is said to run even if there is no infringement by anybody. And my learned friend, Mr. Borkin, accepted yesterday this was the position in response to a question from Lord Justice Arnold at pages 14 to 15 of the transcript. And Dr. Nicholson said the same thing. So no infringement by anyone, the argument still runs against us. We don't have an equivalent of subpara A, which appears in the Dr. Reddy's pleading, which does allege infringement by pharmacists in the counterfactual. Now, that being so, the words in the counterfactual are complete semantics, so far as my clients are concerned, because the only suggestions just said of any infringement by anyone is by pharmacists in the Dr. Reddy's counterfactual. But since that's only run against Dr. Reddy, the words are meaningless here. And it's not as if, for instance, there's one law of patent infringement in the real world and a completely different law of patent infringement in the counterfactual world. The counterfactual world operates in exactly the same way as the real world, saying the orders weren't made. That's the only difference. Now, there's no suggestion on the grounds of appeal the judge misunderstood the nature of the pleaded case as set out in this paragraph. His only mistake is said to relate to the importance of factual causation to the legal argument. But moving on the judgment, paragraph 30, the judge correctly sets out the juridical basis of this alleged defence. It's said to be that because the IPC's all materials times valid, Pfizer was therefore entitled to a monopoly over the use of pregabalin for the treatment conditions covered by the IPC's, irrespective of whether Pfizer could establish a cause of action for infringement against any person. So the judge has clearly understood the nature of the case being made at Pfizer, because that's still their case. And then the judge refers to Warner-Lambert and Sandoz, also known as Sandoz 2, and I'll come back to that. But thus far, the judge is understanding precisely the case which is being advanced, because it's the same case advanced to my lords. And then two important points are made in paragraph 33. The first is Pfizer contends that notwithstanding such use of pregabalin was neither infringement of its patent nor wrongful for any other reason, it would be, quote, unjust and inequitable to require Pfizer to pay compensation based on an allegation that it would have been deprived of its legitimate monopoly arising from the IPC to a greater extent in the counterfactual world than it was in the actual world. Close quotes. So again, the judge is again aware of the legal basis of Pfizer's argument, namely no wrongful act by anyone, and the judge then refers to Abbey Forwarding and Hone number 3. Next, the judge refers in para 34 to the fact that the quantification of damages is best described as an art, not a science. So far as the relevant principles of the actual basis for recovery of compensation under a cross-undertaking is concerned, the judge has correctly set these out. There's no criticism made of this either. And in my learned friend's skeleton argument, at paras 25 to 30, he merely sets out the same principles in more detail. And as my learned friend correctly told the court yesterday, these principles are not in dispute at all. That's transcript page 72. So far, so good. Now we come to the key paragraphs of the judgment for purpose of ground 1. Now, in paragraph 36, the judge says correctly that Pfizer's argument is purely one of law, and because it's purely one of law, it follows it has nothing to do with the facts. Now, that's not criticised by my learned friend, and it does accept that the point of law should be decided now. In paragraph 37, the judge gives his conclusion. In my judgment, this argument has no realistic prospect of success, and the amendment should be refused on that basis. Now, he doesn't say that this is because of, or merely because of, anything to do with factual causation. And I don't accept my learned friend, Mr. Bolton's submission that this is purely about causation in this paragraph. There's more to it than that. And the judge in this passage, I submit, actually gives two reasons of a different nature as to why the argument fails. And the first reason is split across paras 37 and 38. And then the second reason is the one about inequities going on from para 39 onwards. Now, the starting point for the exercise is set out in the second sentence of paragraph 37, where the judge sets out the basis of his conclusions and the judgment. We don't need to go there, but if necessary, it's authorities tab 1, paragraphs 175 to 176, at bundle page 36. But the basis of the exercise is, as the judge says, what would have happened in a counterfactual world where the relevant orders, threats and undertakings were removed, but which otherwise reflected the real world. And that is indeed the correct starting point in law. The judge made the finding. That was one for which the appellants and my clients argued, and there's been no appeal from that. And then in para 38, the judge immediately goes on to say that in the real world, Pfizer could do nothing to prevent off-label dispensing of generic pregabalin for the treatment of conditions covered by the IPCs. And that's because it was common ground, there was nothing wrongful in it, and there was nothing Pfizer could have done to prevent it. Now, this was the same point the judge already mentioned in paras 33 and para 30. And as between my clients and Pfizer, it was indeed common ground, and the judge wasn't talking about Dr. Reddy's pleading at this stage, it was only about our pleading. It was common ground that there was nothing unlawful about such acts. That was paras 30 and 33.
When the judge says in 38, for the treatment of conditions covered by the IPCs, he simply means for the treatment of inflammatory pain.
Yes, he does.
And so when he says there was nothing wrongful in that, that is because what was done did not amount to an infringement of the claims.
Correct. And that was common ground between my clients and Pfizer.
Yeah, and that's all he's saying here.
Now, pausing there, my own friend said yesterday at page 73 that paragraph 38 was, I think his words were, a misreading of the proposed amendments, at least in the Dr. Reddy's claim. Of course, the judge isn't dealing with the Dr. Reddy's claim here. he's dealing with the NHS Scotland claim that he set out in 26 to 27. And of course, as far as my client is concerned, as I already said, there's no equivalent of any allegation of infringement by anyone. Now, just pausing there, and I will go in a moment. It doesn't matter why Pfizer have failed to rely on infringement by anyone in their case against my clients. The fact is they just haven't. It does seem odd with respect that they haven't, because if their argument that pharmacists infringed in the DRL counterfactual were correct, it's not clear why the same argument wouldn't run in our counterfactual, that pharmacists were infringing in just the same way. But if an explanation were thought necessary, it might have something to do with the fact that Pfizer's first attempt to run a case on the IPCs against my clients did expressly rely on infringement, and they abandoned that when they applied to strike it out. That was the day before the new IPC case came in. What actually happened was that the previous case against my clients sought to suggest that inflammatory pain claims had been infringed after all, that the Sandoz injunction was rightly granted to restrain such infringement, and there should be a discount of 13.8% of the damages awarded. Now, I can take my lords to that if necessary, but I'll just give the reference. It's Core 16 248 249, paragraph 39, fourth sentence of their pleading, and paragraph 46C3 of their pleading, Core /16/257. But the point was their previous case positively alleged infringement. And they abandoned that case, as I've said, in the face of a strikeout application. But the very next day, they came back with a case which is currently before the court, which amazingly enough reaches exactly the same conclusion of 13.8% haircut for totally contradictory reasons. And on the face of it, it rather looks like they thought up the argument overnight to keep the desired result going, rather than focusing on the actual logic thereof. Because one could just about see, subject to all the other issues about lateness and Henderson and so forth, how Pfizer might argue, insofar as acts done in relation to pregabalin used to treat inflammatory pain infringe the IPCs, my client should not be able to claim damages due to unlawful acts which were rightly prevented by the injunction. But that's the abandoned case. The current case is my client should not be able to claim damages due to lawful acts which were wrongly prevented by the Sandoz injunction. And that's one of the many reasons why we say the new case, which, as I say, seems to be devised overnight, just makes no sense at all. At any rate, there is no longer any allegation of infringement of the IPCs and proceedings involving my clients. Therefore, it is entirely accurate to proceed on the basis there's been infringement by nobody. And that's the point made by the judge in paragraph 38 of its judgment. And furthermore, we say that since there is nothing wrongful about the acts in the real world, acts relating to IPCs, there is nothing wrongful about them in the counterfactual world either. Because if equity wouldn't prevent such lawful acts in the real world, and the counterfactual makes no difference to whether they are lawful, why should equity suddenly prevent my clients from receiving compensation on the basis that such lawful acts are somehow to be treated as inequitable in the counterfactual world? We say it simply doesn't make any sense at all as against my clients. In fact, it's even quite difficult to even articulate the argument that is the subject matter of ground. Now, I've stressed that the acts were lawful because that was the common grounds as far as Para 38 is concerned. But whether or not the conclusion that Pfizer could have done nothing to stop such acts is correct, exactly the same conclusion would have applied in the counterfactual, where the relevant orders, threats and undertakings are removed. And that's because the IPCs are irrelevant to the only change between factual and counterfactual. So they cannot make any difference to the quantum of compensation because that's measured by reference to the difference between factual and counterfactual. My Lord Justice Arnold put a similar point to my own friend Mr. Bolton yesterday at transcript pages 21 to 22, namely that there is no difference in the circumstances relating to infringement in both the actual and the counterfactual world. And that's why the judge made the point he did in the second sentence of paragraph 37 and in paragraph 38. They're not random comments of no relevance to this part of the judgment, the issue he's considering. On the contrary, it goes to the very heart of why Pfizer's argument, which is the whole of the argument against my client, must fail in law. There's just no difference between the factual and counterfactual. But the judge didn't stop there. He went on to give a second reason why Pfizer's argument was a bad one in paragraph 39 onwards. And we can see its second reason, firstly by the word further, but secondly because it's a very different sort of reason. And the different sort of reason is no longer just comparing the real world to the counterfactual and saying there's no difference. It's comparing alleged inequities. So it's going to the point about, should they be compensated? Should we be compensated? And it compares the alleged inequity to Pfizer of a counterfactual in which sales of Lyrica are decreased because of lawful sales of generic pregabalin to treat a condition referred to in the IPCs, against the inequity to my clients of a counterfactual in which sales of Lyrica are increased because of the chilling effect of a patent which was always invalid. That's the point made in the last sentence of 40. Pfizer's share of the market in the counterfactual world, as in the real world, is calculated on a basis which includes the fact that it claimed a monopoly to which it was never entitled. What the judge's point here is that the effect of his earlier decision, whilst correct in law, did involve unfairness to my clients. And the unfairness is the one identified in paragraph 40. So the judge says, even if refusing the IPC amendment involves any unfairness to Pfizer, it was counterbalanced by the unfairness to the NHS. Now, Malin-Friend complains in his skeleton argument this is a false comparison because it involves two different sorts of unfairness. But with respect, that doesn't make it a false comparison at all. It merely means you're not comparing precisely the same thing. But when you're comparing equities, you very rarely are comparing precisely the same thing. Now, I will say more about these paragraphs of the judgment later, but going back to the grounds of appeal, I've taken my lords through the judge's actual reasoning on ground one. And I'll therefore submit that ground one of the grounds of appeal simply is not made out. It is not true to say that the judge treated the argument as merely raising matters of abstract counterfactual history concerned only with what would happen without reference to the object of the exercise. That is a mischaracterization of his judgment. And the judge actually said the same thing because he refused permission, although my Lord Justice Arnold subsequently gave permission. The judge's refusal, where he didn't accept this was a mischaracterization, is actually in the supplementary bundle at page 202. That's slightly been overtaken by events because now permission has been granted. But permission was granted by my Lord Justice Arnold on the Sandoz point, not because of any reference to mischaracterization. Sorry, not because of anything directly related to ground one. So in conclusion then, I would submit that at no point in these fairly short powers of the judgment does the judge make the mistake he said in paragraphs 4 and 5 the grounds of appeal to have made. At no point does he go into details about counterfactual history. He doesn't get distracted by details of fact. He simply says that he could do nothing to stop the off-label use in either the counterfactual or factual. There's no difference, and he balances the equities at a general level. And at no point does he disregard the principles, the legal principles applicable to the measure of damages to be paid on a cross-undertaking. So my submission, Pfizer just don't like the answer the judge gave to that. But the first ground of appeal is not made out. Now I'll say a little bit more, but that's on the grounds of appeal. On ground 2, there's a suggestion that there's 2 reasons floating around for ground 2. One is novel point of law, and the other is disputed questions of fact. If we look at ground 2, only the first one is actually mentioned there. There's nothing about disputed questions of fact. Para 6 it does say novel point of law and or engaging developing jurisprudence. I understand that. 7 again refers to test for summary judgment, and the last sentence refers to novel point of law engaging developing jurisprudence. And para 8 is about novel, so it's the same point. And the only reference to factual context is para 9, but it's a boilerplate reference. The correct approach would have been to permit the amendments so they could be determined with the benefit of full argument in their proper factual context at trial. Now I say that's boilerplate because the reference to benefit of full argument clearly is boilerplate. And there's no attempt to suggest, well, what facts might be relevant anyway, let alone why such facts would be irrelevant. In fact, the first time that Pfizer suggested there were any factual disputes which had a bearing on this amendment was when they were urging this court not to make a final decision on the allowability, but they've abandoned that position during the oral submissions. Now, I'm going to say a little bit more about ground 2 and say, well, there simply is no attempt to identify what facts, even in the skeleton, might be relevant. And Mr. Bolton has attempted to say, well, why are they relevant? If this is a good point in law, deciding the point of law, why does it matter if it's 13.8 or 13.9 or 15.2 or some other percent? It just doesn't matter. Why do the details about the dispensing and reimbursements regime used by NHS Scotland, what have they got to do with whether this is a good argument in law or not? There is no answer. So it's simply, on the face of the ground of appeal, the novel point of law. Whereas my lords have indicated it won't be novel once it's decided, and all parties are asking the court to do exactly that. Finally, before going into a little more detail about some of these points, as Dr. Nicholson mentioned, in my friend Mr. Bolton's reply skeleton arguments at paragraph 8, which is core 687, he said ultimately ground 1 and 2 do not engage substantive patent law at all. I'm happy to go there. It's core 687. I think I may have had some flicking to that when Dr. Nicholson said the same thing. Core 687, paragraph 8. Ultimately, grounds 1 and 2 do not engage substantive patent law at all. Now that's important because in his oral submissions yesterday, page 75, my own friend appeared to suggest there was something special about Swiss-type claims, which was relevant to ground 1. We say, well, that's wrong at 2 levels. First of all, substantive patent law shows that grounds 1 and 2 cannot succeed at all. And that's for the succinct reasons described by Dr. Nicholson at the beginning, middle, and end of it. My Lord Justice Arnold put it very succinctly yesterday as well. Patents are statutory rights, and there's no monopoly absent of the statute. But nor do we accept there's anything magic about Swiss form claims for the purpose of the argument that's being run. Because if my learned friend is right on his point of principle about the rights conferred to validity alone, even where a patent is not infringed, there's no reason to confine that principle to Swiss-type claims. It would run in every patent case, regardless of the form of the claim. And I don't see why the principle could logically be restricted to claims for damages on a cross-undertaking either. The principle presumably be relevant whenever equitable relief was sought, whether by way of final injunction or interim injunction. I'd also respectfully agree with and endorse what Dr. Nicholson said about shield and sword. I mean, it's convenient to the appellants to say the doctrine only applies as a sword, but what's the logical reason for that? there is none. Now that was all I wanted to say about the judgment and the grounds of appeal. I did want to make some more general points, trying not to tread on or repeat anything Dr. Nicholson has said. It's clear that the case against my clients has to proceed on the basis that there's been no infringement by anyone. And Dr. Nicholson has said at some considerable length that, well, there's not any findings to that effect anyway. It's this long litigation, which has been going for nearly 9 years now. There's no suggestion that the existence of the market for IPC suddenly came to their attention recently or suddenly developed recently. So they could have arranged infringement at any stage. There were some submissions made by both the counsel before me about how the haircut works as against my clients. It's a little bit more complicated against my clients. I am going to explain that and then say why it may not matter much anyway. The reason why it may not matter much anyway is if this is just a judge-made haircut, then the court could simply just do that. Whatever number comes up at the end of the day, then they could simply just chop 13.8%, whatever it is, off. But there'd be no real logic to it, because the argument actually works against my clients in the following way. In very brief and simplified terms, doctors in the Scottish NHS write prescriptions for pregabalin, the first step, and then community pharmacists dispense pregabalin against such prescriptions, and then my clients reimburse the pharmacists for doing so. And we don't need to go into the details of the reimbursement process, certainly not in this hearing. But essentially my clients have different reimbursement categories for prescription drugs and generic drugs, and within each category there will be a reimbursement price for each drug. Now, in the real world, pregabalin was in the prescription drug category at a high price, but following expiry of their patent, it was recharacterized as a generic drug at a lower price level. And our damages claim is really quite a simple one. We can explain as follows. Had the relevant order, which in our case is the Sandoz order, Sandoz injunction order, not been granted, then what happened in the real world would have happened much quicker in the counterfactual world. So it's the same thing happening, just moved forward in time. And in principle, at least, we believe that's a fairly simple claim, because everything that happened in the real world has just moved forward in time. But as Dr. Nicholson rightly said, Pfizer are, seems to us, taking every point possible to avoid paying lawful compensation to our clients, and that's why we've got a 25-day trial. At any rate, that's the nature of our case. So what would the effect of my learned friend's argument be if it's permitted? I don't think he's saying it makes any difference to either the dates of the changes in categorization or reimbursement price. He's not saying any difference to them, or to the quantum of the reimbursement price. From his oral submissions in paragraph 11 of his responsive skeleton, he's suggesting the court should perform some notional artificial market partitioning to get the results his clients would like. And the notional exercise is the court should assume that some of the reimbursement amounts, particularly those amounts paid in respect of pregabalin used to treat inflammatory pain, which in the real world were paid at the higher level, would still have been paid at the higher level in the counterfactual world. Now, there's no legal or business logic to this exercise that we can see. There's no suggestion, no explanation as to how this exercise is going to be done, or when it's going to be done. Is it going to be done in October, or perhaps at some other trial? But the court's going to be expected to do this artificial market partitioning purely to apply the desired end result of the artificial haircut to my client's damages. And we share the same concern as Dr. Nicholson, that we have this 25-day trial in October. And at the end of it, we'll be told, well, we still can't have any money because we've got to work out this complicated market partitioning scheme to decide how much we have to pay you. And the sums are substantial in our case as well if this argument were to succeed?
Well, at the moment, the October trial is for everything other than patent infringement, if patent infringement comes in. So,
Yes.
if anybody were to say that if the ground one amendment is allowed, that couldn't be dealt with in the October trial, they'd need to make that application to the judge, presumably.
Yes, I'm not here making that application to you, but
No, of course not.
the point I'm making is essentially the same as Dr. Nicholson was making about the impossibility of the two buckets and trying to decide, is it the threats bucket or is it the guidance bucket? This is another impossible exercise.
Well, what's that got to do with whether the issue has a real prospect of success? The case that sought to be advanced has a real prospect of success.
Well, insofar as it's going to questions of fact, it doesn't. It's a short answer to my lord. But insofar as how are we dealing with the practicalities of this? How will this argument actually work at trial? I think it can only work on the way that my learned friend indicated in his responsive skeleton argument, and it's yet a further complexity. But if my lord is saying, well, if I win on ground one anyway, why do I need this argument? That's absolutely right. Why do I need this
But
argument?
also, how does it help you if you lose on ground one? Because what you're raising is a case management consideration, and as my lord points out, there may be something in that, but that's not for us.
Yes, that's fair enough. Yes. In that case, I'll move on from that one. I think it's important to understand how it will actually work in terms of practical consequences, but I'm dealing with no reasonable prospect of success.
I mean, I suppose if the judge hadn't found in your favour on no realistic prospect of success, he might have gone on to consider case management, but as it was, he didn't need to.
As it was, he didn't need to, absolutely. Now, the next point is, I should just say about off-label use. We accept what Lord Justice Arnold said, that there's no off-label defence as such. So far as the matter of validity is concerned, again, I would just respectfully agree with and adopt what I think probably is actually common ground, that there would need to be a separate assessment of validity and infringement, insofar as the case against Dr. Reddy depends on infringement. Now, so far as my clients are concerned, there's no infringement, it would only be validity. But we would also have to investigate validity in exactly the same sense that Dr.
Sorry, I don't understand that. If infringement's not an issue against that, why is validity relevant?
Because my learned friend says he gets the rights from mere validity.
Oh, so I see. So your point is, if the basis of the argument is we've got valid claims for inflammatory pain, your potential response is no, they're not valid.
Correct. Yeah. And my lord knows more than I do about the original litigation, but my learned friend Mr.
Sorry to interrupt. I suppose you would say that the strangeness of someone in your position needing to invoke validity when there's no claim that anything they've done, or indeed anyone has done, infringes, just shows that there must be something wrong with this argument.
Yeah, precisely, my lord. And certainly the point I was just about to make was that my own friend Mr. Bolton mentioned only 3 paragraphs in the first instance judgment which considered validity of these claims at all. It was paragraphs 338, 343 and 358. And I actually looked, that was of my lord's first instance judgment in the original Octavius litigation. And of the 3 references given by my learned friend yesterday in his oral submissions, I looked at them, and only one of them specifically mentions the IPCs at all claim to. And that was paragraph 343. But the point I'm on there is simply to say, insofar as there's some conception that the IPCs were subject to detailed discussion in the original litigation, that's simply not right. My clients weren't parties to that in any event. It was Octavius and Teva. But from what we can see, there was very little consideration of the validity of the IPCs. So it cannot be assumed that it's going to be an open and shut case to determine validity second time round. As Dr. Nicholson said, sometimes, as in the Mission and Hoselock case, even with a very full consideration the first time round, Now, some other points about ground 1. I think I've said something about the inequities already to each party, and I've taken the last and correct part of the judgment. But my learned friend's answer to this, as I've understood it, is to say, well, as the law stands, the unfairness to the NHS parties of their claim being artificially inflated because of the chilling effect of a monopoly to which they were never entitled is just something we have to suffer because that's just the law. Now, it's true there are policy reasons why we can't recover compensation for the grant of the patent in the first place. That's true. But that doesn't mean that the unfairness to my clients identified by the judge is any less real. And our response to that would be, well, if you say that the unfairness to the NHS parties is something we have to put up with the result of the law, the alleged unfairness that you've identified to your clients is something you just have to put up with as a result of the law as well. And that was the point that the judge made. Now, so far as the statutory framework is concerned, I do have quite a detailed note, but I think I'll take it very briefly. Having regard to the discussion that happened before I got to my feet, I do agree with Dr. Nicholson. I think my Lord Justice Milton, Lord Justice Arnold, that patent is a statutory right set out section 14.5d, section 60 and section 125. That defines the scope of the rights. It's all a feature of statute, so there is no roving monopoly. There is no rights apart from those which are conferred by the statute. The case law, which was set out in the written submissions but not really developed orally, is a whole series of general statements about the patent bargain, but as my Lord Justice Mill pointed out, that's all about the claimed invention. It doesn't go any broader than that. If my learned friend was right that there is what we call the doctrine of roving monopoly, I've already explained why you can't see why it can logically be determined, it can logically be confined to the particular situation of a defence to damages on a cross-undertaking. And if not, then patentees would rely on it in every case, because my Lord Justice Mill said, if you've got some rights conferred by validity only, why bother with infringement at all? And that can't be right. Furthermore, the whole system of examining patents would have to be reconsidered if that were right. Because if people are getting rights purely on the basis, rights to prevent activity, or rights to allege that certain acts are inequitable purely on the basis of patent being granted without any relevance of infringement, then that system would have to be reconsidered. Now, I was going to say something about the Sandoz case with the same diffidence that my letter of Mr. Bolton had, but I'll make, and the diffidence arises for exactly the same reasons. It's a first instance decision interim by a member of the present court. But I'll make my submissions in the following way. If I could invite the court to go to Authorities tab 7. Now, first of all, I agree with my learned friend, Mr. Bolton, that Lord Justice Arnold is by far the best person to consider this judgment. But like Mr. Bolton, I'll try to respectfully draw the court's attention to various...
Well, it might be said that actually I'm the worst person, having been the author of it, because it's an objective question.
It is an objective. Yes. Well, what I will therefore do is do what I was going to do anyway. The nature of the actual application before my Lord Justice Arnold, Mr. Justice Arnold, as my Lord then was, is set out in paras 1, 2 and 3. And the point about paragraph 2, well, first of all, this is an application to vary an interim injunction. You see that from paragraph 1, and the judge refused that application. And there's a lot of reasoning in this judgment, 115 paragraphs. Now,
I mean, paragraph 80 is the key paragraph, isn't it? That's the one the judge refers to.
yes, absolutely.
I mean, is there in your submission anything wrong with what my lord says there?
Well, it depends what my lord actually meant. My submission is, of course there's nothing wrong, but all my lord was actually saying was that in principle, in other words, if they were able to formulate a case of infringement in due course, then they would be able to rely on such claims.
The context being, see paragraph 78, that they had started to introduce a case of infringement, but it hadn't yet been dealt with and didn't look as if it was properly particularised.
I think my lord's got the point that I was trying to make. And I'll make some other points as well. My lord's got the nub of it, absolutely. I was going to say that claims...
I suppose I can jump in with 2 feet. Where both you and Mr. Bolton may feel a bit nervous.
Yeah, but my lord went right to the answer. That was going to be the punchline. I think it's worth noting, however, that, well, just 2 points. Firstly, the application wasn't about claims 2. There was no actual application to add the condition described by the inflammatory pain claims to the relief, because, as we see from paragraph 2, all they actually wanted to do was add the conditions referred to in claims 10, 11 and 12. So they didn't want to add claims 2 at all anyway. And the only other bit I mentioned in my skeleton arguments was paragraph 29, which is also another reference to claims 2, 5, 7, 8 and 9. It's actually a rather complicated point because my laws have been shown the NHS guidance. Now, my clients weren't involved in the NHS guidance, it was against NHS England. But the point was the original guidance, which is set out here in paragraph 28. Sorry, that's the amended proposal. The original guidance just mentioned pain and neuropathic pain. And the application before Mr. Justice Arnold was to add the subject matter of 10, 11 and 12. And this is a bit of background, as we can see from the heading called the genesis of the present application. The genesis of the present application was they, being Warner-Lambert solicitors, did want a reference to inflammatory pain to be added to the NHS guidance order. And in paragraph 29, Mr. Justice Arnold then points out a number of oddities about the timing and nature of that application. And that's Romans 1, 2 and 3. So it's a particular question which arose in relation to background facts. And at the bottom of the page, when I asked counsel for Warner-Lambert about this during the hearing, the particular question that Mr. Justice Arnold's asking is, well, having regard to facts 1, 2 and 3, why are you making this particular application now, essentially? But the answer to that particular question was, well, the counsel had said, well, the claims have been found valid. And it's implicit in there that mere validity wouldn't have been enough. Now, I accept para 29 isn't dealing with the particular question my lords have to decide. It's dealing with a matter of background, dealing with a question and answer which was made in the context of an application for relief which ultimately didn't go to inflammatory pain claims. But with all these caveats, I would respectfully say it does support our submission that mere validity wouldn't have been enough to justify a variation to the guidance order to refer to inflammatory pain claims. And that goes to the submission my learned friend made as his punchline yesterday, which was quite a tentative suggestion that it would have been possible for the guidance order to restrict the use of generic pregabalin off-label for the treatment of inflammatory pain. Now, whether that submission about it would have been possible add that to the guidance order is, my first point, is some considerable way from the grounds of appeal in this case my clients have to meet. Involves second guessing whether an application, which actually even wasn't before Mr. Justice Arnold that day, would have succeeded or not. And the judgment on the NHS guidance order, I don't believe is in the authorities bundle, and I don't believe my lords have given any submissions on it. But my submission, the results which my learned friend said yesterday would have been possible, would only have been possible if there had been some material to suggest these claims were or were likely to be infringed. And as my Lord Justice Mills has said, it was at a stage when they were in the throes of formulating such a claim. But that's as far as it gets, I think. I don't think the Sandoz 2 proposition gets Malone Friend home in any way, shape or form, because all Mr. Justice Arnold is saying in paragraph 80 is, Lord Justice Mills indicated that in due course some sort of case might have been formulated for infringement of these claims, and if such a claim for infringement had been formulated, then it would have been possible to add them to the subject matter of the guidance.
Mr. Campbell, excuse my ignorance. Does the fact that Pfizer didn't have a marketing authorization for Lyrica for inflammatory pain have any impact on the sort of guidance that might have been ordered?
I don't think it does, because there's no off-label defence as such. You can't say, well, I'm infringing the patent, but I'm doing so in an off-label way.
Well, that's correct, but I think my Lord's question is directed to the regulatory situation, as to which it is unlawful to market a pharmaceutical product for an unauthorised indication. And that would seem to me to be highly material.
Well, yes.
I mean, because the premise of the guidance is, for particular indications, you should only be prescribing Lyrica. And one can see that with neuropathic pain, when that was contended to be the subject matter of a valid patent. But with inflammatory pain, although it may be, and indeed has been held to be in other proceedings, the subject matter of a valid patent, if they have no marketing authorization for it, what business are they doing trying to get doctors to prescribe it? I mean, that was my thought, but yes. I don't know. It was genuinely a question born of ignorance.
Well, to be candid, I don't know either, but it makes sense, because it may be another reason, having nothing to do with patent law, as to why they couldn't have put the inflammatory pain claims into the NHS guidance. Because how can they have official guidance to people if there's no marketing authorization to use it for those things in the first place?
Well, that's why you've got the mismatch in the NHS guidance in the first place. Because paragraphs 1 and 2 came out of the marketing authorization. Paragraphs 3 and 4 came out of the patent. And the whole scenario arises because the patent claims don't match the marketing authorization claims at any level.
Well, that's true, my lord. And that was the comment that my lord made in paragraph 70 of the previous thing, when your lord says here that the application may have been prompted by what your lordship had said in the previous case. Paragraph 70, we can go to it if necessary, but that was one about the mismatch that my lord has just identified. But even then, the reference to, the point then was, well, there was a mismatch between paras 1, 2 and 3, 4. On the other hand, it didn't directly consider the inflammatory pain claims at all, nor does it distinguish between the claims 10, 11, 12, which have been held to be valid and for which there was a marketing authorization, but claims 2, 5, 7, 8 and 9, which have not been held to infringe and did not have such an authorization.
No, that only came in at the Sandoz 2 stage.
So I can just wind up on that one by saying that if my Lord Justice Arnold in this decision did intend to do something which I respectfully say he did not intend to do, which was establish a proposition which assisted the appellants in this appeal by way of reference to it's been called the roving monopoly, he would have done so in far clearer language. And what he did say was that it can be much more easily explained without invoking any such roving principle of infringement. Because if my Lord Justice Arnold did mean there was this doctrine of roving monopoly, it would have all the issues that I've identified before. How would you know when it stopped? Why would you bother proving infringement at all? How do you examine patents for validity? And more concrete terms, it's usual in patent litigation for a defendant only contest the validity of claims that are asserted as being infringed. But if this new argument is right, then, as my Lord Justice Mills said, at some point or other, we should have challenged the validity of Claim 2 as well. But we were never parties to that litigation. We were beneficiaries under a cross-undertaking instead. So potentially far-reaching consequences if my learned friend's submission on the back of this judgment is correct. And I would again agree with what Dr. Nicholson said, was that if this doctrine is to be found in Sandoz 2, it was being relied on as a sword there, not as a shield at all. So there's no support for the submission that, well, we can get it in just as a shield. Now, there was a submission in writing, I don't recall it being made orally, that there was some relevance to a damages inquiry being retrospective. But we say that's entirely irrelevant to the question of law as to whether this is a good argument at all. It's either legitimate in law to permit the haircut, as it's been described, or else it's not. And the fact that you might be able to get a more precise answer with lots of facts about whether it's 13.8% or some other number is simply irrelevant to the point of law about whether it's legitimate to make the deduction at all as a matter of principle. I mentioned that for completeness because I'm not sure if it was actually pressed in oral submissions. Now, unless I can say anything else, that was all I was proposing to say about ground 1.
Thank you very much.
Ground 2, I can be fairly brief on this. I've already said that, well, I've already given away the punchline to this one too, which is to say that the grounds of appeal are just go to novel point of law, and it's not novel once this court decides it. But it was suggested, I think very briefly towards the end of his oral submissions by Dr. Bolton, that it might be relevant to go into interesting factual issues about the NHS guidance order and prescribing practice in Scotland and so forth. And we just cannot see why that can be at all relevant to whether the principle of law is correct or not. And like Dr. Nicholson, we would respectfully say that the moment Mr. Bolton can see that the point of law is suitable for this building now, the relevance of the facts just evaporated. And I believe that was a point made by Lord Justice Arnold as well. We don't even accept that the scope of the jurisdiction to award compensation on a cross-undertaking is developing anyway, because the correctness of Abbey forwarding, for instance, isn't in doubt. All it means, as far as we can say, it's, as the judge put it, there is some room for margin around the edges. For instance, do you apply the strict contractual rules of foreseeability or not? There might be a dispute about that. But we can't detect any dispute of law or any way in which the law is developing which relates to the subject matter of this appeal. And I don't believe any attempt was made. The mere fact that we haven't had to have an inquiry into damages and cross-undertaking of quite this nature before doesn't make the point of law novel. It just means that the circumstances in which it arises at most might be novel. So, Lord, unless I can assist on ground 2, that was almost as brief, I think, as Dr. Nicholson, but there's nothing more to add.
Thank you very much, Mr. Chairman. Mr. Bolton, over to you.
Thank you, Arnold. On Dr. Reddy's amendment to their respondent's notice, we have no objection to Dr. Reddy's being allowed to make that amendment on the 2 subparagraphs that they wish to introduce. Subparagraph B has been addressed by my learned junior, Mr. Austin, and I shan't attempt to traverse any of the same ground. On subparagraph A, one understands clearly the points that Lord Justice Arnold is putting to us about the particularisation of the allegation of infringement. What one can say is that at the time this was argued before the judge, the arguments were set out in considerable detail in skeletons, and they were expanded upon orally over, from my memory, more than one day. And indeed, there had been considerable debate about the inflammatory pain claims in the CAT, in the counterfactual assumptions trial, although that the judge decided that there was nothing before him on which he needed to make a decision. And so we did have particulars behind our argument, but the amendment we accept was not particularized. But everybody knew the basis on which we were making the arguments. The inquiry claimants knew from our skeletons, and they opposed what we were arguing in great detail as well. And we say the judge decided that our case was arguable, and if he had let it in I hadn't applied his other reasons for excluding it, then it would have come in, and of course, in due course, we would have had to particularize it. I'm sure we would have faced requests from Dr. Reddy to do so, and we wouldn't be in this difficult position that we're before your lordships today. But of course, if your lordships were minded to allow the amendment, we would undertake to particularize within whatever time frame was considered appropriate. But I'm assuming swiftly, my lord.
Yes, I see.
The battleground from the last 2 days, essentially, if I can characterize it in this way, it is between my learned friends to my right who wish to argue this for understandable reasons squarely within the boundaries of substantive patent law, and I come before you seeking to invoke additional arguments under justice and equity, and it's the sort of patent counsel against the commercial counsel in how we're approaching this. But if I can put some delineation on that, under substantive patent law, we do not seek to recover damages for infringement or any infringement by pharmacists or anyone else of our valid inflammatory pain claims. The ability to sue for infringement we accept falls squarely within the law on patents, and that was made clear from the discussion between your lordships and my learned junior. But we say recovery of loss under a cross-undertaking engages additional considerations of what is fair and equitable. And so dividing this into 3 separate buckets, as it were, continuing the bucket analogy from Dr. Reddy's pleadings. Point 1, we do not claim damages for infringement of the inflammatory pain claims. Point 2, Dr. Reddy's can keep the profit that it has made from selling pregabalin to treat inflammatory pain. In other words, again, full square, staying within substantive patent law, we do not say that we have any claim that we could be seeking recovery of any profits that Dr. Reddy's has actually made in the actual world from selling pregabalin to treat inflammatory pain.
Or selling pregabalin, which then was in fact used to treat inflammatory pain. Which is
however one deals with that, my lord. I'm clearly at this point, I'm at
Because
such a high level, I'm not making that clear enough for you.
Because they may not sell it for that purpose, but they may sell it to pharmacists who then dispense it.
Yes. However one characterises, and I quite accept what your lordship is putting to me, we do not have any claim to recover the profits they have in fact made in the actual world from selling pregabalin that was used to treat inflammatory pain.
Yep.
So, of course, it's only the 3rd category where we say equity should intervene. And we say that's where it goes beyond what has actually happened into the counterfactual world. And the counterfactual world is, of course, a tool that's used to help the courts and the parties to construct the damages that should be payable. And we say in that counterfactual world, Dr. Reddy's should not be able to claim damages from Pfizer. Pfizer, who invented, discovered the use, published it to the world. And we say Dr. Reddy's should not in equity be able to claim damages from Pfizer in respect of additional sales that Dr. Reddy's would have made being emphasised in the counterfactual world, in that tool to help quantify damages. They are losses that may have been caused by the orders, but we say they are not losses for which Dr. Reddy's should be compensated. And that is the core distinction between damages for patent infringement, for example, and damages under a cross-undertaking.
And that is so, even though in this counterfactual world it would not have been wrongful to do that. It wouldn't have been a tort. It wouldn't have been unlawful. I mean, the judge said it wouldn't have been wrongful, and you couldn't have stopped it.
Yes.
And you don't dispute that, as I understand it.
Well,
on this hypothesis. I mean, I know you have an alternative hypothesis where you'd say it is in fact an infringement.
Yes, and I do try to keep them both alive.
I understand.
At least with Dr. Reddy's.
I understand that. But
No doubt, because it slightly improves the argument if I can establish infringement as well as a hook
yes,
for being able to
but
do this.
your argument is premised on the basis it need not be an infringement.
Yes, but my argument, I say, isn't premised on that, but it survives even if I cannot establish infringement. And that's why it's a more difficult argument against NHS Scotland, where, as my learned friend Mr. Campbell said, there is extant on the pleadings today no allegation of infringement.
Can you think of another example where someone's legal rights are affected by doing something which is not unlawful and can't be stopped? However, morally one might think that they shouldn't reap the benefit of what they're doing, which is really what you're saying. But as a matter of law, there's nothing wrong in them doing it?
Well, I think the distinction, my lord, and I'll go slowly and I hope that someone passes me some bright ideas from behind, but I think in terms of being able to prevent Dr. Reddy's from doing that engages with the issues about whether the patent awarded to Pfizer actually gives Pfizer the scope to prevent it. But I think we're in a slightly different world where we have to consider the equities to Pfizer, where we're in a counterfactual world that hasn't happened, where what is argued is, but for the orders, we would have made all of these additional sales and all of these additional profits from selling something for which you had valid patent claims. And we say that brings in a layer of equity that isn't there in a world where one is unable to...
Is it any more than saying it's terribly unfair that Dr. Reddy should be making profits when we discovered this? Is it any more subtle?
Well, I'd like to say at this stage that I'd put it slightly more sophisticatedly than that, my lord, but I also think, to be fair, that is the nub of the argument, my lord. And we say...
The way you put it suggests that Pfizer is somehow the victim in all of this. But why is that so? Because these orders were not made by the court of its own motion and imposed upon all the parties, including Pfizer. They were made because Pfizer applied to the court for the orders. So to the extent that there's some kind of unfairness, why is the unfairness not attributable to Pfizer's own actions?
Well, perhaps that's something that would have to be weighed in the mix, my lord, but that is not to disregard the inequity to Pfizer that appears to have been recognised by Mr. Justice Zacaroli in having to pay damages to someone in respect of hypothetical sales of something invented and published by Pfizer, something in respect of which Pfizer did have, we say, valid patent claims. And so we say that you are here talking about the potential subversion of public policy in a situation where a patentee who has valid claims under a patent not only can't claim for damages for infringement, but in fact has to pay damages for someone else's use of those valid claims. and we say that's the core distinction from the position that the court reached in Servier and Apotex, because Pfizer has no other way to recoup that loss. It can't go to Canada as could be done by the defendant in that case, and seek to recover its damages from infringement in the manufacturing process elsewhere.
I wonder whether you may not be reading more into the word should in the cross-undertaking than is really there. I mean, the process which happens is that the applicant for the injunction gives that undertaking, and then when it loses the case at the end of the trial, the defendant says, I want to enforce the undertaking as to damages. And at that stage, the court has a discretion to exercise whether the undertaking should be enforced. See, for example, the discussion of that in the Abbey Forwarding and Hone case. And the court may say, no, we're not going to enforce the undertaking. We don't think this is a case in which it should be enforced for whatever reason. But we're past that stage now, because Mr. Justice Bearse's order has decided that the undertaking should be enforced. There shall be an inquiry as to damages. So I would rather doubt whether the word should in the undertaking gives the court some kind of general discretion not to enforce the undertaking if it thinks it results in an outcome which is a bit unfair or anything as general as that. It's still got to be done by reference to established principles, contract damages, foreseeability and so forth, with only such modifications as are necessary to take account of the fact that it is not in fact a breach of contract case, but the enforcement of an undertaking.
My lord, I don't accept what your lordship is putting to me.
Okay.
2 reasons. The first is that the order, I think was in supplemental bundle tab 10 or 12. So page 168 of the supplemental bundle behind tab 10 simply states that there shall be an inquiry as to damages which shall quantify damages suffered by the first defendant pursuant to the cross-undertakings. Yes. So at the stage that is ordered, the court is taking no notice of what arguments there might be as to how those damages are calculated. It merely starts the process of the inquiry. And we say on the authorities, and I'm looking at page 24 of our skeleton of the core bundle. So it's paragraphs 25 and following in our skeleton. It's core bundle tab 3, page 24. We say what those authorities do is set out the principles that will be applied by the court in undertaking the inquiry as to damages. And we say that those show plainly that this is in fact something that requires the detailed application, of course not in every case, but the detailed application of consideration of matters of equity. And so I did cite some of these yesterday, my lord, without going through them in great detail, because I had understood that these were largely agreed between the parties. But the language that I was citing to the court is such as, for example, on the second line in paragraph 27 of Lord Justice McComb's judgment in that just and equitable, all fair and reasonable. And I cited also what was said about this in paragraph 29 in Sigma and Wyeth. And the authorities on which we rely, and I think are not disputed, are replete with suggestions that the question of what should be compensated does bring in these considerations of equity. That doesn't get me home on saying that they will undoubtedly apply in this case, I have to persuade you that having valid claims relating to inflammatory pain is the sort of point that would engage those considerations of what is just and equitable or fair and reasonable. But I say that's definitely a stage that comes after working out what loss was caused by the order. So you do work out what loss caused by the order, and then in some cases that's your answer, and that's what should be paid under the cross-undertaking. And in some cases there will be arguments of an equitable nature that mean the answer is that what should be paid is different from that loss calculated simply by reference to causation principles.
I see.
That was my high-level substantive response, my lord. I'll try and pick up a few of the points of detail that were made by my learned friends, and I will try to do that reasonably quickly. My learned friend, Mr. Nicholson, emphasised the point a number of times that the order of Mr. Justice Burse in March 2020 was an end to the liability phase. And it seemed to me that his argument was essentially anything related to the inflammatory pain claims and allegations of infringement and the like belonged in the liability phase. And once you bring the liability phase to a conclusion, it's too late. You could have and should have raised them earlier. And we say that argument actually plays into what Pfizer is arguing, because if it's right that that signaled the end of the liability phase, what it also did was start the damages phase. We have the order for an inquiry as to damages. And it's only when you have an inquiry as to damages pursuant to the cross-undertaking that the amendment that we are seeking to make becomes relevant at all, because it's an amendment on just and equitable grounds to a loss that's simply done on the basis of what loss was caused by the orders. And so there was no place for Pfizer to be pleading this as a defence to a damages claim under the cross-undertaking at the whatever date this was, in March, 26th of March or thereabouts 2020, because we didn't even have points of claim from Dr. Reddy by then. We received those on the 10th of April, assuming that they were in line with the timetable in that order. And only when you have a claim against you for damages under the cross-undertaking does that engage at all the issue that we're raising under what I call the inequitable or the injustice arguments, my lord. And so it may be that we could have pleaded infringement as a defence to the threats, and assuming that we could have done or even should have done, that we say is not the same at all as saying we could or should have pleaded it as a defence to a claim for damages under a cross-undertaking, where that action had not even been commenced. And that, I think, is also the answer, I submit, to the suggestion from my learned friend, Mr. Nicholson, that we're trying to run the infringement case again. We aren't trying to run the infringement case at the liability stage. We're simply saying we should not have to pay damages in respect of claims that had been held valid. So we are not having a second go at arguing what claims should be held valid or invalid. We are not applying any kind of appeal against the claims that were held invalid. We are saying something very different, which is certain claims were held valid. That was not appealed, and it's on that basis that we found our injustice argument. I was half expecting that the court might be addressed on Servier and Aptex and Patel and Mercer. But without the cases before the court, I was going to confine myself to highlighting that we did run this argument in detail at first instance for Mr. Justice Zacaroli, and one can see that within his decision at page 125 of the core bundle. That's tab 9. And what Mr. Justice Zacaroli summarizes there, top of page 125, is that Pfizer contends that the illegality doctrine, the rationale for which is that it would be contrary to public interest to enforce a claim if to do so would be harmful to the integrity of the legal system. Patel and Mercer per Lord Toulson is equally applicable to prevent an inquiry claimant recovering a particular part of the damages claimed. Now, in that hearing, we did argue before Mr. Justice Zacaroli that Patel and Mercer had changed the position as it was under Servier and Aptex. It's right that Lord Sumption focused on the type of illegality and was looking for something criminal or quasi-criminal, although it's also right to say that Lord Sumption's reasons for deciding that the public policy argument didn't apply were also because the only relevant interest affected was that of the patentee, and he said that was sufficiently vindicated by the availability of damages for the infringements in Canada. But Lord Sumption in that case was clearly in support of a rule-based approach to turpitude or illegality. And when one gets to the Supreme Court in Patel and Mercer, the Supreme Court, with Lord Toulson giving the leading judgment, says that we should be moving away from a rule-based approach. And we would say that would include a rule that says you must have this kind of illegality. And what Lord Toulson proposes is something that is a balancing in the particular facts of the case, which needs to take into account, the underlying purpose of the prohibition, any other relevant public policy, and to consider whether denial of the claim would be a proportionate response to the illegality. So there is no clear statement in Patel and Mercer that says how Lord Sumption viewed illegality was the wrong test. But what it does do is say the better approach from now on is to apply not a rule-based approach, but a balancing exercise founded on public policy that takes into account the circumstances of each case. And that was our submission to Mr. Justice Zacaroli, which I commend to this court as well. And as Mr. Justice Zacaroli notes in paragraph 52 of his decision, no points were taken by NHS Scotland or Dr. Reddy's on that, on the merits of that argument. And hence, Mr. Justice Zacaroli thought that it was arguable, and my learned friends here who were at that hearing did not take points against that argument at that stage. A couple of minor tidying up points, and I will be done before 4 o'clock unless your lordships have many questions for me. I think my learned friend Mr. Nicholson got himself slightly confused with respect on the chronology behind the order at supplementary bundle tab 14, and I think he did seek to correct some of this. But the factual chronology, which can be made good if anyone needs me to do so, is that the amendments were proposed in accordance with the timetable that had been set by the judge in November of 2021. And so, for example, when one looks at the amendments from Pfizer in the Dr. Reddy's defense, I'm just seeing if they are dated. I thought there was a date on them, but I can't immediately see it. I'm sorry, I'm looking in the wrong place, but I'm grateful to those behind me. I thought these had been sent through in November 2021, but it may well be there in December 2021. That's the date that appears on page 197. We were before Mr. Justice Zacaroli in early January 2022, or something like the 10th, 11th, 12th, or that's within a day or so. The skeleton arguments were all prepared on the basis of the amendments that have been proposed by the parties. So there was no last minute changes of position on this. My learned friend, Mr. Campbell, always likes to talk about how Pfizer withdrew its pleadings of infringement and then thought up some new arguments overnight. But he knows, because I've told him formally on many occasions, that all that actually happened was that the wrong set of amendments were sent to NHS Scotland, and then the error was realised and the correct amendments were sent the very next day. So he likes to make a lot of that point, but it's not proper in my submission. And then what actually happens is the hearing takes place in early January, and then Mr. Justice Zacaroli, at the end of that hearing, here's an application from my learned friend Mr. Nicholson, who, as usual, seeks to be excused from the multi-party litigation and to go its own way and have its own damages inquiry. And he says, no, for the umpteenth time, I'm not going to allow that, but I will change the structure of the future trials and we'll have one 25-day trial. But he sets that, and the order is the one at supplementary bundle tab 14. But it's plain that there's nothing implicit in this order about whether there's going to be an infringement trial or anything, because page 199 makes it plain at paragraph 9 that a determination of Warner-Lambert's amendment application, directions to trial disclosure, are otherwise adjourned to the hearing following handing down of judgment in Warner-Lambert's application. So the application we had made to amend, the judge had, for very understandable reasons, reserved judgment, and therefore he issued an order that took no account of what his findings might be on that decision.
Right.
My learned friend Mr. Campbell started with a forensic analysis of what was in the grounds of appeal with regard to paragraphs 37 to 42 of the judge's decision, and I do not argue with the way that he analysed that. What that means is that our grounds of appeal focused on paragraph 37. The judge did not give us permission based on our grounds of appeal and said that the parties should also be looking at his reasoning at paragraphs 39 to 42. By the time we came to write our skeleton, we did focus also on paragraphs 39 to 42 and the balancing of inequities. So it was live on our skeleton. The inquiry claimants knew we were arguing that, but we did not go back and amend our grounds of appeal. And so that was an oversight for which I apologise, and I am certainly happy, my lords, to undertake that we would, in the same way that I last night and my learned friend Mr. Nicholson at lunchtime come up with a very brief formal application to amend to include reference to paragraphs 38 to 42 of his lordship's judgment. There was you were taken into the patent law in terms of section 4 subparagraph 2 of the Patents Act to support an argument that what that shows is that methods of treating conditions are not allowed under section 4 subparagraph 2 of the subclause 2 of the Patents Act. And all we say to that is that in the light of the explanation of Swiss form claims to which your lordships have already been referred, my understanding and therefore my submission is that Swiss form claims are in one sense an attempt to get around that prohibition that you were shown in section 4.2 of the Patents Act. Turning pages is good news, my lords. It was suggested that there was no logic to the distinction that Pfizer seeks to bring between the use of these arguments as a shield and a sword. And to the extent there is a logic to it, I would say that that is because the sword is rooted in substantive patent law and the ability, for example, to claim damages for infringement or obtain an injunction. But the shield is rooted in concepts also of equity, which is why we bring them in under our injustice arguments. It's a little bit by the by, but I'm almost done. The suggestion that the 25-day trial is because Pfizer is taking every point, I should just for the record point out that the length of the trial was in part predicated on National Health Service, England, Wales, Northern Ireland being a party, with very complex claims relating to a detailed investigation of PPRS and medicine margin. But one of the complexities is that the NHS and Dr. Reddy's can't both be right. And one of the things Pfizer has sought to do over many years with the support of the courts is to say there should be one counterfactual and one hearing of these damages inquiries. Dr. Nicholson has never liked that because my simple point that he and the NHS cannot both be right is in the NHS counterfactual world, there is mass generic entry early and prices crash, which is a very good case for the NHS because that's where their loss of profits comes from. But it's very bad news for Dr. Nicholson and his clients because Dr. Reddy's would not have made tens of millions of profit because they would have been selling in a mass generic market at very low prices. And I mention that only to show those are the sorts of complexities that will come out at a damages inquiry because they can't both be right on what they argue. And each of these inquiry claimants will be having to prove their case on what they say would have happened in the counterfactual world. I made submissions on the judge's balancing of inequities, and what we say is any inequity to the NHS to be taken into account would have to come in only once one had worked out what was the loss that was caused to them by the orders. You can't start from a higher loss that might have been caused by the grant of the patent. Under the undertakings, it's the loss caused by the inequities. Then one could bring in inequities, but that's not what the judge brought in. He brought in a supposed inequity that arises before you get to losses that are caused by the order. And really, he just didn't have the information before him to balance any of the different inequities because they weren't argued in full, but only in principle. My lords, unless I can help you further.
No, thank you very much.
I'm sorry, I didn't look behind me to see if I could help you any further. Apparently not. That's good news for me, my lord. Thank you very much.
Well, thank you to you, Mr. Bolton, to all counsel and to the teams supporting them for some interesting arguments. We will need to think about those arguments and will therefore reserve our judgments. They will be sent to those whose names have been put forward for that purpose in due course when they are ready in draft. That will be for correcting any errors of a typographical or minor factual nature, and we will then finalise the judgments and hand them down remotely, so there will be no need for any attendance. In the light of the draft, we hope that you will be able to agree an order between you. In some cases, that proves to be a forlorn hope, but we do live in hope. If you are unable to do so, please make short written submissions on any points in dispute, and we will deal with those without a further hearing. I need to remind you formally of what I'm sure you're already aware, which is that there is a strict embargo which applies to the draft judgments with limited purposes for which they may be used until they are finalised and handed down, and the court nowadays takes any breach of that embargo extremely seriously. I'm sure everybody's well aware of that, but you'll understand why I need to say it. That then concludes the hearing of this appeal. Thank you all very much indeed.
Also,